Welcome. This is Court of Appeals, cause number CA-CV130523, Ciccarello versus State. Am I saying that correct?
Yes, Your Honor. I believe it's Ciccarello.
Ciccarello. Okay. This is a time set for oral arguments. For your information, these proceedings are being recorded. The podium in front of you, as you approach the podium, please state your name and who you are representing. The podium will have the amount of time that you have. Each side will have 20 minutes. The podium will tell you how much time you have left. The appellant, you may reserve a portion of your time for rebuttal. And if you'll tell us how much time you want, we'll try not to horn in on your time. If the podium says you have 10 minutes, you want 5 minutes for rebuttal, that 10 minutes includes your 5 minutes of rebuttal. As I said, the proceedings are being recorded both audially and visually, and if the equipment works correctly, you may be able to see yourselves on YouTube. We have read the briefs and read relevant portions of the record, discussed the case in conference before oral argument today, so we are familiar with the facts and the issues. And with that, you may begin.
My name is Marlon Branham, and I am appearing on behalf of the appellants in this particular matter, namely the mother, Rhonda K. Ciccarello, representing herself, and on behalf of the surviving relatives. The matter currently before the court is a wrongful death action for Eugene Ciccarello. He was an inmate at the Arizona State Prison Kingman facility. The inmate passed away after becoming ill and receiving no medical treatment for several days following the symptoms of his illness. The decedent's symptoms were consistent with pneumonia, and an autopsy concluded that the cause of death included complications from pneumonia. The decedent's mother...
Well,
Yes, sir.
it seemed that other than some bacteria associated with it, it was with respect to drug use, both in the coroner's report as well as in Mr. Keene's report, Dr. Keene's report. So how do you get that he passed away due to a disease that's otherwise preventable to at least what's contained in the record?
Yes, Your Honor. Our understanding from both reports, actually, and in speaking of the reports, I guess I may as well indicate that there was a report done by Mojave County medical examiner.
Correct.
Okay. And there was a second report prepared by an independent medical examiner
Correct.
done later. Further, the understanding with the reports is that, number one, the job of the examiner is to try to determine the cause of death, but then they also have to go in and determine manner of death. Getting to your question, Your Honor, basically the report does indicate that, in both reports actually, that there was pneumonia listed as one of the causes. What they further try to elaborate on in the reports is that the pneumonia was likely due to some sort of drug usage, thus the intravenous part of it. And our understanding, again, is that the intravenous part deals with some sort of needle. So thus the bacteria must have entered the body by way of a needle, thus leading to the pneumonia, which complications, as we stated before, as a result of the pneumonia led to the death.
So, well, but that's that, but I don't see that, there's testimony, anything in the record that either the forensic pathologist or Dr. Keene has said that if you use intravenous drug, it may in fact create bacterial pneumonia, which could kill you, as opposed to having pneumonia, using drugs and then having the combination of both, create the mechanism of death.
Yes, Your Honor. the reports do indicate, and I believe, again, this is per both reports, that there was some suggestion, thus by way of some marks on the decedent's arm, and I believe it was his left arm, if I'm not mistaken, that showed some puncture wounds. There was no discussion, however, as to the age of the wounds. There was very little discussion as to whether or not there was a conclusion, or I strike that. There was discussion surrounding whether or not the drug usage caused the death. Basically, by way of the toxicology reports, although opiates were found in the system of Mr. Cicciarello, there were no other drugs found in the system. The medical examiner did talk around the issue of drugs and basically ruled out the idea that that the death was actually caused by way of drug usage. Again, the report really talks more about what really led to the death, which was the pneumonia, a bacteria related to, or excuse me, a bacteria that caused the pneumonia.
Okay.
With the
Wouldn't you
decedent.
then need some sort of an additional to Dr. Keene, then some expert testimony to help explain to the trial court that it was more likely than not that it was the pneumonia that killed Mr. Cicciarello, as opposed to, at least what both people seem to say, that bacterial vasculitis due to multiple bacterial emboli from intravenous drug abuse. Because that it seems to say the drug abuse killed him, as opposed to pneumonia killing him.
Right. And again, Your Honor, with all due respect to the court, again, we have to go back to the toxicology report, which does indicate quite clearly that there was not the toxicology report, but a reference to the toxicology report in the medical examiner's report. Basically, the reference suggests or states that although there was a toxicology done, thus trying to determine whether or not there was a drug overdose, the toxicology basically had no effect on the cause of death. That was listed in the medical examiner's report, that the toxicology report was not significant in terms of any findings as to the cause of death.
I think, though, that what troubles me is you've got these reports saying the bacteria caused pneumonia, and you've got the bacteria coming in from drug abuse, but you have nothing that says this man died of pneumonia, and I think you need to have an expert who would say that for you, and you don't have that. You need to have something that ties the two together, and an expert that ties the reports together. You know, he didn't die of a drug overdose because there wasn't enough drugs in his system, and he did have pneumonia, and that was the cause of death. You know, kind of talking about the whole thing, the causation. And I from what I've seen of the record, that's missing. And if I'm missing something, then please correct me.
Right, and again, our understanding of the medical examiner, and this is where the case is a little difficult on that issue, because we really hadn't gotten as far as determining whether or not there were going to be depositions. So your point is definitely well taken. In the event that there were depositions, we all would have had the doctors, each of them, expound on their particular positions. But going back, and we can even start and just really focus on the Mojave County Medical Examiner's report, she's listed several causes if we take a look at that first page of her report. And clearly one of those causes is listed as a type of pneumonia. There are different types of pneumonia. Again, I'm not a medical expert. I couldn't testify even if I were in this particular case, but we would need those doctors to be able to testify as to what all that means. But that said, the medical examiner's job, the way we understand it, is very different from that of a doctor who would go in and try to determine a cause of death. The medical examiner's position is a little more strict in terms of what they're looking for and what they're deciphering. For instance, the manner of death would, as the court probably is full aware, would be determined as homicide if there was some sort of gunshot wound or murder. In this particular case, the medical examiner, at least the IME, independent medical examiner, indicated that he had a problem with listing the manner of death as natural causes. Why? Again, we'd have to have that doctor elaborate on it, but he does try to at least insert some suggestion there that this was an accident. Nobody deliberately gave Mr. Cicciarello pneumonia or the bacteria that caused the pneumonia. It was an accident, regardless of whether it came through drug usage or some sort of needle, or if he just picked it up from the air.
And I understand that, but what it sounds to me like you're saying is that you didn't get to do enough discovery when the motion for summary judgment came in. Did you ask for more time to take some depositions so that you could come up with the information you needed?
Well, independent of our response to the motion for summary judgment, Your Honor, we did not ask for more time, but in the response we did make the attempt to allege that there was certainly insufficient time to be able to further identify those issues that could help to clarify the positions of both medical examiners. And so, yes, the time could have helped.
Yeah.
Rule 56F seems to say that, if there's stuff you need to do, you've got to ask for it and tell the court what you want and how much time you might need before you respond, so that the court can then manage and keep everything on track. Because at least, as I'm looking at the autopsy report, Exhibit O, pulmonary vasculitis, multiple bacterial emboli, both acute and subacute, bacterial pneumonia, NOS, cardiomegaly, pulmonary congestion and edema marked. Some of that stuff that I understand over the years in practicing and talking to my son when he was going to medical school. But how that gets put together and what that might mean as to the other circumstances of, did he have pneumonia? Did the department, through their staffing, know that he had pneumonia? And the other stuff that would set the foundation to get you at least where the court didn't think you got to.
And so on behalf of the appellants, we believe the position would be such that that presents sort of a fact issue. I mean, there is a medical expert. There are two of them here. Both of them have testified, well, excuse me, not testified, but they both commented on the issues regarding the pneumonia. What we need is them to further explain that. And basically the lower court rather, indicated that there was medical expert opinions that was lacking, or excuse me, that there was no medical expert opinion regarding a standard of care issue. Appellant says that's not true. There was and is the medical expert opinions, but there just is some clarification with regards to the issue of the pneumonia and how the pneumonia may have impacted the decedent's passing.
So what do you think are the genuine issues of material fact that may exist as a result of the court's ruling that would otherwise still continue to exist?
Well, one of the material facts would be, to the court's point, the causation issue. Do the reports directly tie the cause of death to pneumonia? After determining that particular issue of fact, there's yet another issue where we believe the trial court also indicated that he was granting a motion for summary judgment, and that was based upon the suggestion that there was no comment as to whether or not treatment, had it been given to Mr. Cicciarello 2 weeks prior to his passing, whether or not that treatment would have in fact saved his life. So,
but that also would be expert testimony that would be needed. Correct? No one other than a doctor could say that if he had asked for and had been given penicillin, for example, okay, that 2 weeks worth of penicillin on a regular basis would have helped resolve the pneumonia.
Correct, Your Honor. But we do believe that would be something that, again, our argument is that it's really resolved. It's just language that we don't understand within the medical examiner's report. But to your point,
But isn't then that your...
it could be clarified by way of medical expert testimony. But another fact issue, which the appellees have contended, is that they received no notice. They weren't aware that Mr. Cicciarello was sick. And of course, the appellant's argument is how do you, 2 weeks of being ill, missing several meals, running high fevers, not leaving his bunk area, you have head counts that occur. No one noticed that Mr. Cicciarello was weak, incapable of feeding himself, or was running high fevers. Not to mention the fact that we have a Mr. Steele, as you know, a witness here, who indicates that he personally had to assist Mr. Cicciarello in submitting what they call an H&R, which is just a health needs request in a written form. So the appellee takes the position that, well, that never happened.
But what happened to that? Okay? If he says, if he did it, okay, and we don't know, but we also don't know what should have happened with that, okay? What, according to DOC's regulations, should have happened to the H&R, once it was submitted? And maybe, that's additional room for discovery, as well as, deposing some of the staff who would have been in the cell block during that period of time as to what, if anything, they may have or not noticed.
Correct, Your Honor. Well, appellant would certainly agree, and appellant does maintain. Look, Mr. Cicciarello was incarcerated. It's not like you have a lot of friends on the outside that can come to your assistance when something like this happens. And so the issue we took with the trial court judge on this, and I'm going to try to reserve a few minutes here at the end, but the issue, we've got to say this, that we took with the trial judge is he completely discounted Mr. Steele's assessment, his interpretation of what he experienced and what he saw. When there's no one else in there to speak up for Mr. Cicciarello, we think that in a light most favorable to the appellant, the judge at least has to consider that. So again, we would like to reserve just a few minutes here for rebuttal if needed.
Okay.
So, thank you.
Thank you.
Good morning. I'm Denise Troy. I'm representing the state of Arizona. I will try to keep this brief because I don't believe I have that much to say, but I'm Irish, so I gab a little bit. As the court just noted, there is no proof of the cause of death of Mr. Cicciarello. It may have been pneumonia. It may have been a drug overdose. Plaintiff had the burden to prove the cause of death. Appellant had the burden to prove that if Mr. Cicciarello had received medical treatment, he would have survived. Appellant had the burden to prove that what the standard of care is in the jail if and when an H&R is received. Appellant had the burden to prove as the standard of care for corrections officers when they see somebody who is in his bunk, appears to be ill.
Well, would it be a standard of care or just, having some testimony that there were correctional officers who may have noticed that he didn't look well, as opposed to having to do something, but to independently corroborate that it was 2 weeks before he passed away or whenever he may have had pneumonia, if that was the case, that they noticed that he was ill, and then at least under the department directives or regulation, then they were required to say something to somebody.
Well, that would be appellant's burden of proof because we have absolutely they took no depositions. We waited until the expert deadline had passed before we moved for summary judgment. In fact, we asked them to provide us expert testimony before we filed the motion for summary judgment to give appellant the opportunity to support their case, and we were provided Dr. Keene's report, and that's the only expert report we received. And they needed expert testimony, and they didn't provide it. They did not ask for additional discovery after we filed the motion for summary judgment. They didn't come to me and say, could we have an extension? They didn't move the court under Rule 56F. And it's not in their brief, in their responsive brief on the motion for summary judgment that they actually asked for discovery. Instead, they said medical expert testimony is not necessary in this case. That's what they said in response to the motion for summary judgment. And clearly it is, because there is evidence that Mr. Cicciarello died of an overdose, and it wasn't pneumonia, and we have no proof of what happened except Mr. Steele's self-serving declaration. Oh,
Well, we know, at least through Dr. Keene, that it was an accident.
Correct.
We don't know really anything else.
Precisely. And the appellant had the burden of proof in the court below to bring forward enough evidence to withstand a motion for summary judgment. And as the court is well aware, that is not that high a standard. It's something a reasonable juror could go, yes, that's why this happened. Jurors, as a general rule, do not understand policies and procedures and guidelines that occur in our prison system. So they would have needed expert testimony, not only on what the policies and procedures are, but what correctional health professionals are required to do when faced with somebody who has not personally requested their help. We don't know, as we stand here today, whether the HNR was submitted, and it's not in the record, but in the documents that were provided to appellant, there is no sign of any such document. Because I would guarantee if there were, we would have seen it at some stage. In addition, did somebody look at it and take action on it? We don't know. They did no discovery to find that out. Did the corrections officers notice that Mr. Cicciarello appeared ill? We don't know. They took no discovery on that issue. Was Mr. Cicciarello suffering from pneumonia 2 weeks prior, as Mr. Steele says in his declaration? We don't know. No medical person examined him. He could have had allergies. He could have had a bad cold. He could have had the flu. Mr. Steele is not a medical expert who can testify as to what was wrong with Mr. Cicciarello 2 weeks before his death.
Well, if you had some expert testimony and with his observations, would that have been sufficient to have at least created a genuine issue of material fact? Doctor said, well, based upon what Mr. Steele saw, okay, it could have been.
I don't think that's a high enough level, Your Honor, unfortunately, because...
Oh, we don't have the expert testimony, I understand,
But even if we had an expert testimony which said, based on Mr. Steele's statements and the medical examiner's report and Dr. Keene's report, it is likely that Mr. Cicciarello was suffering from pneumonia 2 weeks prior to his death. That would create a fact issue on did he die from pneumonia. It does not create a fact issue on whether prison staff and correctional health professionals breached the standard of care to take care of Mr. Cicciarello, because there is nothing in the record that shows they failed to do that, because there's nothing in the records that shows they knew or understood that Mr. Cicciarello was actually ill. There's all kinds of reasons that prisoners don't get out of their bunks. Some can be ill, some can just be, as somebody has explained it to me, doing the Rip Van Winkle, which is they stay in bed as long as possible because it is so mind-numbingly awful in prison that they just don't want to get out of bed. Could be sick, could have had drug issues. We don't know, because nobody deposed the correctional officers. And they would still need an expert to say the correctional officers breached their duty to Mr. Cicciarello by failing to alert the medical professionals that he was ill. We have none of that. So it's not just a medical expert, it's a correctional health expert, it's a corrections expert on what the duty was to this person. And the state does not deny that under Estelle v. Gamble, it owes a duty to provide reasonable medical care. However, there is no proof what, in this instance, reasonable medical care would have been. They offered nothing. And I agree that it's tragic that the man died in prison, but there's no proof that anything the state or any of its agents did caused the death or could have prevented the death. Does the court have any other questions for me?
No.
Thank you, Your Honors.
Thank you.
Well, appellee attempts to suggest that the H&R was needed in order to establish the standard of care. Obviously, appellants disagree with that. The standard of care, the duty has all been created as a result of the ARS section 31-20101D. In addition to that, what appellant really urges is that, pneumonia aside, the case is one for wrongful death for Mr. Cicciarello, who was visibly ill for over about 2 weeks. There was no care provided. So if we want to determine a question of fact, there's another question of fact based upon the idea, the suggestion, the expert opinion of Dr. Keene, who says quite clearly this was an accident.
Well, it was an accident, but there's no indication. Well, I think he's saying it was an accident because of the drug overdose, as opposed to it was an accident because no one saw it. There's nothing in his report that suggests that employees of the Department of Corrections did anything or didn't do anything that they should have otherwise done. He was just looking at the medical report.
And with all due respect to the court, we respectfully disagree. Dr. Keene does not suggest any drug overdose. In fact, it is just the opposite. Dr. Keene does suggest, he actually corroborates more or less what the Mojave County medical examiner suggested, in that the bacteria related to the pneumonia may have been done intravenously, which is thus the intravenous drug terminology that's used there. But there is no conclusion, if you will, that there wasn't a drug overdose.
Well, correct, because at least Dr. Keene, I'm looking at his report, says it appeared that a more appropriate designation may have been narcotic lung due to intravenous narcotic use.
Sorry.
Okay, now what that might mean and how it might inform the trial court or this court, those are words and we don't necessarily know what they mean. Probably if I'd asked my son, he could probably tell me, but I can't do that.
So with regards to the issues that the appellant will try to urge here, the matter is really just mind-blowing in the sense that the appellee suggests that there has to be some sort of H&R that's submitted before the health staff inside the penal system will take any action.
No, what I think that they're saying is that there's got to be some evidence that they're put on notice, okay? And if they don't have the H&R, is there some other evidence? And it may well have been that guards were noticing that exactly what Mr. Steele was noticing, okay? And if there were, did they have an obligation then to report that to supervisors or health staff or something, either based upon the regs or other directives, or just being good people. And if someone would have gone in and said, well, he just didn't want to get up because he didn't want the bad food, that's one thing. But if he's, and I made a note about what vasculitis means, fever, headaches, fatigue, night sweats, weight loss. If they were concerned that there were other things going on, then, but the evidence isn't in terms of what the staff may have known and should have done, doesn't seem to be there.
Right. In conclusion, Your Honor, the appellates would just reiterate that there doesn't appear to be a need for medical expert testimony on a standard of care issue with regards to whether or not someone who has high fevers, who's not able to make meals, who's clearly unable to get out of bed under his own strength, whether or not that was reasonable. A jury could determine whether or not it was reasonable to withhold any type of treatment to an individual under those circumstances.
Thank you, counsel. We will take the matter under advisement. We'll issue a ruling in due course, and with that, we are adjourned. Thank you.